Hello, my name's Ian Larkins of Radius Law and welcome to our commercial bulletin in association with LexisNexis. The UK's new Vertical Agreement Block Exemption Order, VABEO, became law on the 1st of June, replacing the EU Vertical Block Exemption Regulation, VBER, which had been retained in the UK under domestic law post-Brexit. Here's a quick summary. VABEO exempts certain competition law rules from supply chain agreements, such as franchise agreements. There is a 1-year transition period. In parallel, the EU has replaced the VBER. The VABEO and the VBER are similar, but there is some divergence. There is an allowance for differentiated wholesale prices to help with the additional investment needs for physical stores. The new VBER has similar changes, albeit with more strict conditions. Wide parity clauses whereby a product or service may not be advertised on better terms on any other channels will not be permitted under VABEO, although the VBER does not have the same absolute prohibition. The accompanying guidance provides more information about agency agreements, and there are some small differences between the EU and the UK guidance. The VABEO will be reviewed in 6 years, whereas the VBER has been set for 12 years. A recent decision of the High Court has suggested that model articles for private companies are not suitable for sole director companies. Model articles are the standard default articles a company can use. Article 11.2 of the model article states the quorum for directors' meetings may be fixed from time to time by a decision of the directors, but it must never be less than 2 and unless otherwise fixed is 2. Accordingly, for sole director companies, we recommend that the model articles are amended as otherwise decisions taken by that director may be invalid, and passing a shareholder resolution to ratify any past decisions taken by the sole director. The government has unveiled its new proposals for the UK's post-Brexit data protection regime. Whilst a few proposals are still under consideration by the government, the following has been identified as forming part of the data reform bill. Removing the requirement in certain circumstances to conduct a balancing test when using legitimate interest as your lawful basis to process personal data. Imposing requirements on companies to conduct a privacy management program to evidence how they process and safeguard personal data. Substituting the obligation on some organisations to appoint a data protection officer with an obligation to identify an individual within the organisations responsible for overseeing data protection compliance. For removal of data protection impact assessments. A relaxation of the requirements relating to consent for cookies. And extending greater powers of enforcement to the Information Commissioner's Office, the ICO. On the 25th of May, the European Commission released guidance for the Standard Contractual Clauses, the SCCs, that it implemented in June last year. Subject to meeting other requirements, SCCs can be used to lawfully transfer personal data to a country that has not yet been approved by the EU or ICO as having adequate data protection controls. As you may recall from previous vlogs, the SCCs are still relevant to UK data exporters post-Brexit, provided the UK Parliament approved addendum is used. Key points in the Q&As include that the SCCs can be supplemented with additional clauses and/or incorporated into a broader commercial contract, provided that it does not contradict the SCCs. If organisations use SCCs, this should be stated in their privacy policies, together with information on how individuals can obtain a copy of the clauses. The ICO has launched its AI and Data Protection Risk Toolkit. The toolkit is a risk assessment tool to help organisations using AI, artificial intelligence, to manage the risks to individuals' information rights caused by such processing. Since the 1st of July, fit notes certifying sickness absence for employees can be written by a wider group of healthcare professionals, including pharmacists and nurses. A statement of fitness for work, known as a fit note, is an official written statement that provides a medical opinion on an individual's fitness for work and is a requirement to obtain statutory sick pay following 7 days of absence. 3 recent cases have given reminders to employers of their duties to prevent harassment in the workplace. In one case, a tribunal has held that a claimant who was called an expletive in relation to his baldness at work was subjected to harassment. The tribunal agreed that such banter was unwanted conduct that related to his sex because baldness is more prevalent in men. In another case, a 69-year-old employee has been awarded £13,000 for injury to feelings for being referred to as half-dead Dave by his teammates and his supervisor. The tribunal agreed that this name-calling in this case was age discrimination. The tribunal dismissed the employer's argument that it was just workplace banter and that it should not be liable as the employee had not objected. Finally, a woman has succeeded a claim of harassment when her employer failed to provide somewhere private for her to express breast milk at work, requiring her to use the car or toilets instead. Now, it's worth noting that employers won't be liable where they have taken all reasonable steps to prevent harassment from happening by making reasonable adaptations and having robust policies and training in place. There was surprise and disappointment that the long-awaited employment bill, which had been expected to contain measures in relation to tips, additional rights for 0 hours workers and pregnant women, neonatal and paid carers leave, and default flexible working, as well as bringing in single enforcement body for employment rights, was not included as part of the government's legislative agenda in the Queen's speech. The government has, however, now announced a new review of the future of work. The review will be led by Matt Warman MP and will be conducted over the spring and summer this year. Employers often seek to protect their businesses by including post-termination non-compete clauses in the contracts of their key employees. If a key employee then leaves and joins a competitor, the obvious next step is for the employer to issue an interim injunction, i.e. an injunction to immediately stop the employment with the competitor until there is time for a full hearing. Now, the Court of Appeal has recently considered such interim injunctions. The following points are worth noting. Unless the former employee is very wealthy, or if the ex-employer is willing to pay the former employee during the period between the interim injunction and the full hearing, the court may refuse the injunction. Don't delay. Whilst there was disagreement amongst the Court of Appeal judges about whether the 7-week delay before issuing the injunction in the current case was fatal to it, it's clear that the longer the delay, the more risk there is for the success of the interim injunction application. If a non-compete acts as a total bar to other appropriate employment, the clauses are unlikely to be justified as reasonable. On this last point, a recent High Court case has provided some useful guidance, stating that where the non-compete is restricted to 12 months and to the parts of the business where the employee had a material involvement, rather than all of the business, then the non-compete provision is more likely to be enforceable. That's it for this month. Thank you for tuning in. We have included the links to all of the documents we referred to today in the written version of this bulletin. But please don't hesitate to reach out to me or any of my colleagues here at Radius Law for more information.